She sued her boss for $340K. Her own method destroyed her case. She sued her former boss for $340,000 over a dog training method she claimed he stole. What she didn't count on was her own dog taking the stand, metaphorically speaking. The plaintiff had spent 11 years building what she called her life's work. A certified animal behaviorist, she had developed what she described as a proprietary framework for rehabilitating aggressive dogs. A 12-step desensitization protocol she'd named the Calm Threshold Method. She'd documented it obsessively. Handwritten journals, video logs, time-stamped training session notes going back to March of an early spring 7 years prior, when she accepted a position as head trainer at a mid-sized pet rehabilitation facility in the Pacific Northwest. She brought that method with her. And when she left that job 18 months later under difficult circumstances, she alleged her employer took the method with him. The defendant was the founder and owner of that facility, a former veterinary technician who'd built the business from a single rented kennel into a 3-location operation over 12 years. By his own account, he was a pragmatist. He hired the plaintiff because she had a reputation. He said he valued her contributions. What he denied, firmly and consistently, was ever stealing a single thing from her. The lawsuit was filed in civil court on a Tuesday in late autumn. The plaintiff alleged misappropriation of trade secrets, breach of an implied confidentiality agreement, and unjust enrichment. She was seeking $340,000, an amount she calculated based on the facility's revenue growth of 34% in the 14 months following her departure, which she attributed directly to the implementation of her method in their marketing and intake protocols. On the stand, the plaintiff was composed but visibly emotional. She described the moment she discovered her former employer was using the phrase "calm threshold" in a client brochure, a brochure that outlined a protocol nearly identical to hers step by step. She testified that she had never signed over any rights to her intellectual property. She had brought the method to the job, she said, not created it for the job. Her attorney introduced 47 pages of documentation, journal entries, email drafts to colleagues at other facilities, and a workshop registration from 4 months before she was hired. Proof, they argued, that the method predated her employment entirely. The defendant's attorney pushed back methodically. His client took the stand and acknowledged that, yes, the Calm Threshold method was being used at the facility. He did not deny it. What he denied was theft. He testified that the plaintiff had introduced the method during a staff-wide training session she'd conducted voluntarily, that she had presented it as a tool for the whole team, and that she had, in fact, encouraged the staff to adopt it wholesale. He produced meeting minutes from that session. He produced emails from the plaintiff herself that read, in her own words, "I want this to be the foundation of everything we do here." His argument was simple. She gave it away. The plaintiff's attorney objected that intent mattered, that sharing a method for use within a workplace was not the same as surrendering ownership of it. The courtroom felt the weight of that distinction. Then came the moment that changed everything. During cross-examination, the defendant's attorney introduced a publication, a regional animal behavior newsletter from 8 years prior, predating the plaintiff's journals by nearly a year. It outlined a 12-step canine desensitization framework developed by a retired behaviorist in rural Montana. The method had a different name, but the structure, the sequence, the threshold terminology, the graduated stimulus approach was nearly identical to the Calm Threshold method. The plaintiff, visibly shaken, acknowledged she had read that newsletter. She could not say with certainty, under oath, that the publication had not influenced her work. The room was quiet for a long moment. The judge deliberated for 6 days. When the ruling came, it was neither a clean victory nor a clean loss. The court found that the plaintiff held legitimate claim to her documented refinements and her specific application of the framework. The branding, the structured intake process, the proprietary client-facing materials. These the defendant had used without compensation or credit. On those grounds, she was awarded $47,500 in damages. But the broader claim that the core methodology was exclusively hers to begin with was not supported by the evidence. That portion of the suit was dismissed. The defendant paid the judgment. The plaintiff's attorney called it a partial vindication. The defendant's attorney called it a lesson in reading the fine print before you sue. Their professional relationship, such as it was, did not survive. Neither did the plaintiff's lawsuit against the Montana Newsletter's estate, which was filed 3 months later and quietly dropped. The calm threshold method is still used at the facility today. The plaintiff now runs workshops independently, and her client brochure includes a line about its origins that is carefully, deliberately vague, which leaves the question hanging. If you build something remarkable on top of someone else's foundation, and you genuinely didn't realize it, does that make the work less yours? Or does innovation always owe a debt it can't quite bring itself to acknowledge?